And just so everybody knows, at home and here, all of the workshops are available again, usually about 24 hours after the workshop itself. We then have them available on our YouTube channel. So perfect. Okay, let's get started. So I'd love to introduce our guests. We have, and if you guys want to come up here, this is Erica Lee and Emily. I'm not going to pronounce your Kirschenhuter, and from New Media Rights. We've actually done lots of workshops together in the past, and I'm just excited that you guys can be back here and tell everybody about the amazing resources that you have available with New Media Rights. So with that, I'll pass it over to you. I think Angela, do you have everything all right over there?
Yeah, I'm just trying to hide the bar.
Oh, the toolbar. Right, that's good luck with that one. At least it's not like right in our faces, right? True.
Hide floating controls. There we go.
Perfect. Okay, and
Standing in the way here, maybe I'll.
I think you're not on the first slide again. Is it?
Yeah.
All right?
Move it over here.
And
Oh,
there we go.
Okay.
Welcome.
Cool.
So, yeah.
Hi, everybody. So welcome to Legal Considerations for Startups. Sorry, I'm kind of standing right in the middle of the screen here, but that's okay. My name is Erica Lee. I am the Assistant Director at New Media Rights. And Emily, I'll let you introduce yourself.
Yes, I'm Emily Kirschenhuter. I'm currently a 2L at California Western and a student fellow at New Media Rights.
So today, before we kind of jump into some of the main meat and potatoes of the presentation, I just want to take a moment to talk about what New Media Rights is, what we do. So as far as like what we are a clinical program of California Western School of Law, so downtown San Diego. And there are kind of like three big components to what we do. First and foremost, we offer free and low-cost legal services and a lot of those services we provide to like tech-related projects and startups and small businesses. We also work a lot with like creative professionals as well. So designers, filmmakers, musicians, those types of folks on a number of different preventative transactional matters. So what does that mean? A bunch of buzzwords there. It means that we try to get in on a project that you might be working on early and help you kind of assess what you're doing and help you spot some potential legal issues or things that you could avoid so that you don't get yourself into legal problems down the line, right? And just transactional, meaning that we don't do litigation work. So we're focused a lot on like contract drafting and review and some of those other kind of issues that that might pop up outside of the litigation context. So, but aside from providing direct assistance, we also engage in some educational work and some public policy work as well. So if you go to our website, newmediarights.org, we have a number of different written guides. We have a YouTube channel, which is a lot of fun as well. And we have a book called Don't Panic, and it's a legal guide that's written more in plain English that's understandable to everybody. And we have like a fair use app as well. So a number of different resources that are all kind of geared towards taking a lot of these complicated topics like intellectual property law, right? And helping translate that into something that's a little bit more understandable, right? And then as far as our public policy work that we engage in, from time to time, we'll write comments to the Copyright Office or to the FCC, the Federal Communications Commission, when they're putting out different studies on different areas of the law and different regulations. And so because we work with a lot of smaller independent creatives or small businesses and startups, we find ourselves in a bit of a unique position to be able to advocate for those folks who can't necessarily afford, thousands and thousands of dollars to hire like a lobbyist or someone to advocate on their behalf. So that's a little bit about our organization. We're doing a lot of stuff, right? But as far as, some of the specific services that we offer, this is just a brief example. It's by no means an exclusive list, but just to kind of get you an idea of some of the things that we do on the day-to-day basis. we first and foremost, right, we're working on preventing and triaging copyright and trademark issues. So those are two different areas of the law. There's some crossover, right? But they are different. And so you might be thinking about things like copyright ownership and licensing of things that you're creating. And so questions might come up in the sense of like, well, are you actually the owner of this project that you've been working on for months and months and months, or is somebody else? Can you even move forward with your project based on that ownership status, or is there maybe something that has to happen first before you can really keep moving on it? We're known for our work defending against improper DMCA takedowns. So what is the DMCA? It stands for the Digital Millennium Copyright Act. And it's a section of copyright law. It does many things, but one of the things that it does is it allows copyright owners to take down infringing works from the internet in a very easy and kind of quick and efficient way, without having to like actually file a lawsuit against those infringers. Now, there's a lot of nuances and stuff that are involved with that, but as you can probably imagine, there's some legitimate uses of third-party content that gets swept up in some of those. And so we tend to step in and help defend against some of those improper takedowns that get sent. So you've probably seen it before if you go to a YouTube video and all of a sudden it's like, oh, this video has been taken down under the DMCA. That's kind of what I'm talking about here. Let's see. So we also can handle kind of triaging the cease and desist letters or demand letters that hopefully no one in this room will ever get, right? But I think the key thing to remember about these types of nasty lawyer letters is if you ever get one of these, do not ignore it. You should immediately contact attorney, whether that's someone at our organization or another attorney that you might know, because there's usually like a deadline for some of the demands in there. And, even if the ultimate game plan is we're not going to entertain this, or we're not going to meet these demands, you really don't want to ignore any of those timelines. Because, sometimes they're scare tactics, some of these letters, but sometimes they're not. So very important to pay attention to those. In addition, I'm not sure what happened here to the sidebar, but that's okay. I'll talk about all these. We also do some contract review and drafting work. Now, the caveat here is that we're only licensed in the state of California. So if, for example, you're presented with a contract that's based in another state's laws or another country's laws, chances are we probably won't be able to advise on the majority of that contract, just because it's like a jurisdictional issue. We can't talk about the laws of the states or countries in which we are not barred in. So that would not be very responsible. But anyways, right, if you are presented with a contract or you need a contract drafted, that would be a good moment to reach out to either us or another attorney. I also have up here terms of use and privacy policies. These are things that we can draft and review. You may have heard terms of use also referred to as like terms of service or like an end user license agreement, a EULA, right? But they're very important to have in place if you're running an interactive web service, right? It's important that everybody understands kind of the rules of the game and what things you want people to do and not to do when they're using your service. And critically in California, privacy policies are very important. They're required. So you need to be able to tell people what type of information you're collecting from them and how you're using it, what you're doing with it, and be transparent about that. So that's something that we can assist with. We can also do some counseling on privacy and data aggregation issues. And then in addition, online consumer disputes. These come up a lot more than you might realize, even if it's just, I'm selling something on Etsy or on Amazon and I'm running into some problems with some people. That's something that we could potentially assist with in some way. Okay, so I have up on screen here some other resources. I think I mentioned most of these before when I was talking about some of our educational work. All of these are available on our website. This is our book.
We have a couple copies of this too in our library up front if you want to check it out.
Awesome. Yes, thank you. can't get away without some shameless self-promotion. Thank you. So yes, it's on Amazon too.
It's called Don't Panic, right?
It's called, yep, it's called Don't Panic. It's got a long title, A Legal Guide in Plain English for Small Businesses and Creative Professionals. But if you just type in Don't Panic with a smiley face, usually it comes up. So our focus today, now that I've kind of talked about our organization, and I'm more than happy to answer questions about the organization later. Our focus today, because we don't have a whole lot of time, right? There's so many different things we could talk about. We're going to focus on a couple of common areas where it's pretty easy to make mistakes, right? So we're going to talk about copyright and we're going to talk about contracts, and then we'll leave some time at the end for some Q&A. We can only really talk about big picture and general concepts though. So if you have a specific legal question about something that you are working on, please don't ask that in this room here in front of everybody. For confidentiality reasons, we won't be able to answer that question for you. But you can always feel free, if you do have a specific question, go ahead and go to our website and click on the contact us form. There's a button up at the top where you can submit a specific legal question that you might want to talk to an attorney about, and we can go from there. But yes.
That's how they set up a meeting with you if they are.
Yes, absolutely. If you're looking for a consultation, we offer free consultations. So that would be the place where you can do that. Someone has entered the chat.
Just a little bit back. So you guys can sort of climb up in here.
Oh, thank you.
Oops.
Oh,
Maybe
lost
that
our
was-
And we
connection.
lost our connection.
Right.
Sorry about that.
Yeah.
Tangent.
Little too short.
Yeah, well, that's not great.
I know, we just moved into the space. so-
Yeah, sorry about that again.
Yeah.
No worries.
Thought I was hoping, but.
Gonna do a little.
Oh, so this is-
You're good. All right. All right. So.
Let them up pretty quickly.
Oh, got it. Sorry.
Quickly.
I see it up here. So,
I think you need to. You mind if I ask a question? Well,
sure, absolutely. Go for it.
when it comes to hiring of your services,
Mhm.
do you guys function like as a subscription? Is it a retainer? How does that work?
Yeah, great question. We operate on what's called like a limited scope basis, and it's flat fee. So what that means is we work kind of project by project. So we don't do like a retainer. But if there is a charge for our services, that's generally a one-time payment that happens at the start of the representation, and that's it. We do, like I said, we do also offer some pro bono services depending on the particular situation. But hopefully that helps answer the question. Cool. All right, we're back in action. So I have on screen here this slide that says, well, when do I need to talk to a lawyer? This is a really common question that comes up. And so it's worth thinking about, a handful of points in the life cycle of your project or startup where it should probably trigger a discussion with a lawyer. So first up, I'm selling a good or a service. At this stage, you're probably starting to think about logos, brand names, maybe a company name. That's a good time to perhaps reach out to a trademark attorney. Trademark law protects things like logos and brand names. It's designed to prevent consumer confusion, right? So it's designed to prevent someone from thinking that a good is coming from one individual or company when it's really coming from someone else, right? And so if you're starting to kind of develop that branding, probably a good time to talk to a trademark attorney. And it's good to do that early because you don't want to invest a ton of time and money and other resources into like hiring someone to create a logo, pushing out some marketing materials, only to later discover that somebody else already had that trademark before you did. That can actually be kind of a business killer sometimes. So worth thinking about if you've got something in mind that you want to try to protect, worth thinking about talking to a trademark attorney at that moment. I also have up on here, right, patents and trade secrets. if you have come up with a new invention, or you have a new method of doing something that's novel and non-obvious, that's a good time to talk to a patent attorney, right? We don't practice in patent law. We're not barred under the patent bar, but if that's something that you're looking for, we do have resources in the San Diego community that we can provide for you. Trade secrets, if you don't know what that is, that's basically a trade secret is something that derives its value from being kept secret. So classic example here would be like the Coca-Cola recipe for their soda. Or it could be like a marketing strategy, for example, that you want to keep secret because it's particularly valuable. Let's see, if you're running an interactive service in any way, you might be starting to think about like liability for certain content that's on the site. So if you're trying to start like the next Facebook, you're going to be wanting to think about like liability associated with content that users are posting to your site. And this kind of circles back to what I was talking about before, the DMCA. Aside from giving copyright owners some ability to enforce their rights, one of the other things that area of the law does is it provides some protections for interactive services so that they aren't held directly liable for things like copyright infringement, right? If someone goes on your site and posts a picture that they don't own, right? You don't want to get dinged for that as the interactive service. So that's something to chat about as well. There's also going to be, depending on what industry you're in, specific laws that might affect your business. So for example, if you're taking a dive into the healthcare industry, there's a lot of laws in that area about privacy, right? And what information can be shared and collected from folks. There's environmental laws. You might come across some like food related regulations and laws, right? If you're making some sort of food product. I want to work with someone else, a team, a contractor, or some other entity, right? This is a big moment for a lot of people. Again, there's this question of like, okay, we're getting together to do this thing or to create this software, right? For example, you're going to be thinking about, well, who actually owns the code that we're generating here? Is it me? Is it my business partner? Is it both of us together? Is it our entity, right? These are all things to kind of think about here at this early stage. You might also need some contracts, right? If you're just trying to hire somebody to do some work for you, you're going to want something in writing to memorialize that arrangement and make sure that everybody understands the obligations and the relationship that's being set up. And then something that's not up on here, but that comes up from time to time are when you're trying to work with someone else, there's always employment concerns as well. Right. In California, for example, it's a lot harder to hire like an independent contractor if they're going to be doing the same work that your company, for example, is going to be doing. It didn't used to be the case, but a little bit trickier nowadays. And you really don't want to misclassify folks that you're hiring because that can come with some pretty serious consequences as well. Let's see. So the next kind of moment where you might consider talking to a lawyer is, well, I'm going to be starting my own web service or my own app. At that moment, like I said before, you want to be thinking about rules that you want to establish for your users. You definitely want to have a privacy policy in place. You're also going to be thinking about things like the Digital Millennium Copyright Act and those safe harbors, right? What can I put in place to help prevent certain liability, certain risks, right? I have up here also like the CDA, which that stands for the Communications Decency Act, which again it's another law that prevents lawsuits against services for what their users are saying, right? So the point, right? What's the big point of all this? If you forget everything else that I've just kind of rambled about and come away with one thing, you should talk to a lawyer early, right? Don't wait. And at the very least, talk to somebody before you start to invest time and a lot of resources and money into launching your product or your service. And I think now we'll be handing it over. I'll hand it over to Emily, who will talk a little bit about some copyright law basics. I can control the slides. if you
Okay,
want.
thank you.
A little easier.
Right, so copyright law. Copyright law is designed to protect creative works. But how do you get copyright protection? When does a work become copyrightable? And I'm going to walk you through 3 elements. They're not on the slide that makes a work copyrightable. First, it has to be original. And the bar for originality is very low. There just has to be a small amount of creativity for it to be original. The second, the work has to fall into a category of a protective subject matter. And this protective subject matter is listed in the statute itself, but all it is, it's very broad. It's literary works, right? Those are going to be books, those are going to be codes, audio-visual works, musical works, dramatic works. So the work has to be a protected subject matter. And then the third element is that it has to be fixed in a tangible medium of expression. And what does that mean? It just means it has to be saved. It has to be written on a piece of paper. It has to be painted on an easel or saved to a computer, right? You write your code into a computer, or you save a Word document, or you take a photo and it's on film or a hard drive. It just has to be fixed within some sort of tangible medium. So those are the 3 elements that you have to meet. And once that work is fixed, once it's saved, you automatically receive copyright protection and you get these bundle of rights. So you get the right to reproduce and distribute your work. So you're the only one that can make copies of your software and sell it to others. Now, distribute doesn't exclusively mean sell. You could give it away, but again, you're the only person that can give it away. Also, you have the right to perform or display your work. So you're the only one that can perform that song, or it can post that photo online, you display the work. And then we have create new works based on the original work. And this is what is called a derivative work. And we see it all the time. It's when you take a book and you turn it into a movie, or maybe you make a video game using the characters from a book. You're the only one that can create those new works based on your original work. And you can also authorize other people. You're the only one that can authorize somebody else to create works from your own work. And these rights are designed to help the creator control their content, but they don't last forever. Copyright protection, these rights expire. So the basic rule is that most works created after 1978 are protected for the life of the creator plus 70 years. Or if it's a company that's creating work, it's going to be 95 years from the publication of that work, or 120 years from the date of creation, whichever comes first, whichever expires first.
Yeah, exactly. Thank you very much, Disney.
Yes. And then moving on, let's talk about the types of works protected by copyright. We already said it has to be original, it has to be a protected subject matter, and it has to be fixed in this tangible medium of expression. But a key point that we need to remember here is that copyright does not protect ideas. It protects the expression of those ideas. And I want to take a moment to talk about that distinction. So right now I'm watching the show, The Last of Us. I don't know if you've heard it. It's the new HBO show about a zombie apocalypse, right? And the premise is simple. There's a pandemic and there's a virus that is turning people into flesh-eating zombies. So, right, you've heard this before, right? A virus that turns people into flesh-eating monsters, zombies. But how are they allowed to do this if we know shows like The Walking Dead exist, movies like Dawn of the Dead or 28 Days Later? They all sound pretty similar, right? But it's when you take that idea of a zombie apocalypse and you flesh it out into a script, no pun intended, and you add a narrative, you add characters, you film it, and you add your own look, your own aesthetic twist to it. Those are expressions. That is your own expression of those ideas. And we don't want to stifle creativity. So think about if we did have copyright over these ideas, we'd never have any of these TV shows or any of these movies. We'd be stuck with the first zombie movie or book back in the early 1900s. Yeah, go ahead.
I just had a question. So what about the content of web pages? Is that copyrighted?
Yeah, so the content of web pages is, especially if you're talking about the source code behind it, and also if you have a photo, that photo itself, right, is copyrighted.
Yeah, and there's an important distinction there in the sense that like the web page itself isn't necessarily protected, but the content on it is. But yeah, like Emily said, the underlying source code can also be protected if it's sufficiently original. Good question.
Great, so like I said, it doesn't protect those ideas, but it's the expression of those ideas. So once you have that idea and you create a creative work based on it and it fits into the protective subject matter, then you'll receive copyright protection. Some examples of protected works are things we see all the time, like books, comic books, photographs.
Would a company like a slogan be copyrightable?
Ooh, what a great
What a great
transition.
transition into our next slide. What is not protected by copyright? So like we said, ideas are not, facts are not either, right? So that's why, you know, if a journalist is writing a story about a road that's closed down the street, another journalist can write that same story, but they'll express it differently, right? But that's the fact of the road that is closed. That fact is not copyrightable. Titles, names, short phrases, and slogans are not protected by copyright law. Now, they can be protected by trademark, but that's a different area of law, and copyright does not protect those things. Also, processes and systems are not protected, but they could be possibly protected by patent law.
I have a question, I think I know the answer, but recipes, what about recipes?
Recipes are not, those are facts. So like how to hard boil an egg is a fact, but if you put a recipe into a book and you know, that book is copyrightable and the expression of that recipe, but the recipe itself is not copyrightable.
Yeah, that's accurate. And I think more specifically, right, because a recipe is at its core just like a list of
Right, it's a
things,
process.
right? And we know that that's not protected, just a bare bones list, not protected. But it's like when you start adding that narrative of like, oh, grandma brought this recipe over from the old country, right? And she like added this twist to it that really amplified the flavor of this, you know, dish. That is the expression that can be protected in a recipe. Yeah.
Great, and federal government works are actually not protected. They are in the public domain. So what that means is it has to be a work that's created by an employee of the federal government within their official duties. So you can use them, but you really want to make sure that you know that it is in the public domain and that it was created by an employee. So you don't just want to be going to a federal government website and taking photos because, you know, they could be, you know, they could have a contract with a photographer. But if it is made by a federal government employee within their duties, then it is free to use and it is not protected by copyright. And then other works in the public domain. What's the public domain? So like we talked about earlier, copyright protection does not last forever. When copyright protection expires, the work falls into the public domain and it's free to use without permission. So that's going to be any works generally published before 1928 are in the public domain. Works between 1928 and 1978 have different rules associated with the copyright lifespan. So that's when, if there is a work that was created between that time frame, that's when you would want to reach out to an attorney or reach out to us to determine whether it's in the public domain. And also, if you're using content in the public domain, it's incredibly important to know for sure that it is available for you to use, because you know there can be a lot of confusion. We see it at New Media Rights a lot, where you know they're unsure, and if you use something that's not in the public domain, then you could be infringing. So if you want to use public domain, it's important to know that it's in the public domain.
What about legal contracts? So if I get a contract from a company and I want to use that contract for another company, can I do that?
I mean, it's a great question. And, you know, we all use templates all the time. And I don't know off the top of my head whether like there's a case that came down that said like contracts are, you know, protected. And if you use it, it's infringing. That would probably be a little bit outrageous if a court ever really did come down that hard on a contract in terms of like whether it's protected and using it is infringing. It's kind of similar to most case opinions that are issued by judges when they decide on a case. Those are generally in the public domain. We don't want that information to get locked down. So yeah, it's interesting because the nature of contracts are largely private and confidential, right? So you're not going to be like publishing a contract. And so I think even if they were protectable, the likelihood of someone claiming it was infringement to use that contract is probably pretty low, but it's a good question. And not one that I really have a solid answer for off the top of my head.
How about privacy policies? So like, it's easy to
Mhm.
copy privacy policies on the website and put it on the website.
Right,
So
right.
Is that illegal or is that?
I wouldn't say it's illegal per se. However, and I'll actually talk a little bit about that exact circumstance in a couple of minutes, but it's not something that I would recommend. Just because contracts they should be, and privacy policies are at their core a contract. They should be uniquely tailored to the particular circumstance, to the particular company, because sometimes having just a copy of someone else's privacy policy can do more harm for you than good, right? Because it's not accurate. So I think it's less of a copyright infringement claim and more of you are opening yourself up to liability on other fronts, if that makes sense.
And I think a lot of entrepreneurs will do that. We copy things that are already out there. And just
Sure. I mean, we all do that, right? That is the like fundamental principle of innovation, building off of one another's works. But I think there are lines in certain places, right? So yeah, no, it's a great question.
There's one other, we don't know that contract is up to date. So legally, you can be copying something that's out of date and you have all the liability that person has.
Right, that's a great point too.
poorly written.
So yeah, this is great. You guys are coming up with really great. Yeah, so I think that's it for this side.
Yeah, so let's talk about the benefits of copyright ownership. And like I said before, that those bundle of rights are automatic once you create that work. So you don't need to register your copyright to get those rights, but there are a lot of other benefits that come with registering your copyright, and it can actually be really important, especially it's critical when it comes to damages and when it comes to seeking an attorney to help you. Because if you register your copyright, you can get two things. One are attorney fees and statutory damages. So when we're talking about statutory damages, they can be significant, and it can be $750 up to $30,000 per infringement per work. And if you can prove that it was a willful infringement, so if you can prove that they knew that they were infringing on your content, then you can get up to $150,000. And a lot of times, if you're seeking help from an attorney, it's going to be hard to get that help if you don't have your copyright registered. So we highly recommend to do that because there's a lot of money on the table if you ever need to enforce your rights. Some other benefits of owning copyright is you have the ability to license or assign your work. What are these? A license is when you grant permission to someone else to use your content, through one of those rights. So maybe you are licensing to perform your play, or if you post a photo to Instagram, you're actually giving them a license to display your work, but you're retaining your ownership rights over that content. Whereas an assignment is when you're permanently transferring your ownership in the copyright to someone else. And we can see those terms are used interchangeably a lot, which they shouldn't be, because obviously you can see they're very different. So if somebody asks you to assign your rights to something, just know that means you are giving up all of your rights in that copyright. And maybe you should ask them if a license might be more appropriate.
I have a question.
Yeah.
When you says upload YouTube, so then you would need to copyright each video, or There's like your channel name and everything, all the content that's in it? Or how-
So the answer to that question is the frustrating lawyer answer, which is it depends, right? It kind of just depends on the circumstance. Now we've all seen those YouTube channels where people are uploading content daily or weekly, right? Very frequent. And so for some of those folks, right, registration might not really be a feasible option because registration is kind of expensive. I think it's like $65 a registration, and that's just for one work. Right, so like one video. Now there are group registration options, but not for like every type of work. Like I don't think there is a group registration option for published videos, like YouTube videos yet. But for example, like with photographs, you can register like up to like 750 photographs in one registration. So and photographers fought really hard for that option. But so it really depends on the particular circumstance and what makes the most sense. So one thing that we often talk about is, okay, if you are creating a lot of content and you think that maybe like a couple of these out of the bundle of 10 are going to be go viral or be really popular, or you want to exploit them in some way, right? Like you want to put ads on that content or you want to do something with it that's going to generate revenue for you, then maybe that's a time to consider registering that particular video, right? Because you want people to know that you are the owner, right? So yeah.
So I just have a quick question, just to clarify, I'm not sure that I understand. You can only get recompense if it's copyrighted legally, not if it's just de facto copyrighted by the creation of it.
Good question. The answer there is no, right? There are damages available if you're not registered, if the copyright is not registered. However, it's nowhere near the amount that you would be entitled to if you do have a registration, because the statutory damages are quite literally, that range is written into the statute, right, as a starting point that a judge can use. But if you're not registered, then I believe the only thing that's available are actual damages, which after you do the math, it comes to zero or very, very little most of the time. And so, yeah, that's why, like, if you have something that's really popular, that's the time to consider registering it. Because yeah, the likelihood of then being able to claim those damages is much higher. Yeah.
You mentioned it's about $65 for copyright registration. That's for the fee for the copyright itself. Ballpark, what is a typical lawyer?
Good question. It really depends. Since we're not in private practice, it's hard for me to like kind of estimate what the fee would potentially be for a registration. So I think it would probably just depend on their going rate and experience. But some I would imagine do it for a flat fee, right? So the one-time fee, but it really kind of depends. But yeah.
And that's something that you guys can do.
So as far as copyright registration, that's usually we don't, because there are like a lot of private sector attorneys that are engaged in that and can actually do it probably quicker than we can. And so that's not actually a service that we provide. We can kind of advise and give some guidance on the process, because I've been through the process before and it's not fun. But yeah, so there are kind of limitations to what we can do on the registration front, but in general, we won't be like submitting the application for you. So yeah, sorry, that's a little bit frustrating in terms of estimating cost, but yeah, that really depends depending on who you're going to. So yeah.
Just side note, talking about privacy policy and all those things. So recently, if I client, just to test it out, we use ChatGPT, right? What a fantastic policy. Red sweat seem pretty cautious, I don't know.
It's funny that you bring that up. Been having a lot of discussions about ChatGPT. And it's I have my personal thoughts on the AI. And I myself have tested the AI in similar instances. That being said, a big part of contract drafting is context, right? And a computer, an algorithm, doesn't quite fully grasp the surrounding context. and it's hard to kind of teach that context or prompt that context to the software, right? So I'm always a huge proponent of using the human lawyer, even if Chat GPT is a starting point, right? Having that person who can help check that the policy fits the context and the facts of the situation. Again, will put you on more solid footing. Again, that's my personal opinion. But you know, I am of the thought that AI has some interesting potentials and possibilities, while at the same time being very scary. So hopefully that answers that question.
Here's what you should know. If you ask that same question a minute later, 2 minutes later, you're gonna get slightly different. No, it's done on purpose.
Yeah, it's
It actually
regenerative.
is done on- That's right, because they actually have that built in.
Yeah, so they want to.
So which one do you want to use, the first, second, or third?
Well, that's it, so they are actually, right now, they are going to release very soon, I think they're going to release the legal package of ChatGPT. Which is like legal documents, and that's supposed to be, within, I think, it'll take 2 or 3 years for it to learn, and I think that will go, you can kind of depend on it.
Yeah.
So that's where it's headed to, the technology.
Mhm.
And the privacy policy I took, we did send it to a lawyer to take a look at it.
It's a
I'm
good,
waiting
it's a
for
good
the
starting
response.
place usually. I mean,
Yeah.
I found.
I'm waiting for a response from lawyer to see how they find any issues.
Did you tell it you were in California?
Mm.
Yes, yes.
Yeah, I think you have. Anyways.
Yeah, no, I mean, I'm glad you brought it up, because it's, like you said, this is where the technology is going, and we have to sink or swim with that technology. So, but we're getting a little sidetracked. I know you have a question. Okay, so we've talked about licenses and assignments.
Yes, so what if you want to use someone else's content? And one big thing here, I know it seems very obvious, but just want to drive the point home, is that if you did not create the work, you don't have the rights to use it. So what do you do next? There's a couple ways to use someone else's work. The first one is you need permission. So you need to get a license or an assignment, but licenses are obviously more common. You can use it in fair use, which, you know, I'll talk about in the next couple of slides, but it's a doctrine that allows you to use portions of someone else's work without permission, but you have to meet some basic factors. Or you have to make sure it's in the public domain. Getting a license is definitely, I think, the best way to use someone else's work. Go ahead.
So a logo is not a copyright, right? Would a logo animation fall under that?
A logo animation.
Moving logos. what you
Yeah,
put
like,
on.
so I had a logo created by,
Mhm.
I'm not the creator of the work. But he used my logo and then animated it and tweaked it. So essentially, I don't have the right to use that without getting a license from him.
So I'm not going to answer that question.
I know you.
It's a little too specific, but I will say that logos, yes, are generally receive protection from trademark. But in some instances, those same logos can also receive some copyright protection because they are an illustrative work, right? So there are layers to that protection. So it's not necessarily that it's wouldn't apply, that some of these laws wouldn't necessarily apply. But I think that's the limit of answering that question. But that would be a great question. Okay, but that would be a great question to write into us about. So, yeah.
Yes, so getting a license. How do you do this? Generally, you're going to have to negotiate with the copyright owner, and that means tracking them down. And honestly, that can be a battle in itself, is figuring out who actually owns the copyright. Because sometimes the creator doesn't, they may have already licensed it, or there could be many factors. So you need to track down the copyright owner and try to negotiate with them. But there are other ways to find content that you can use. Online, there's a bunch of openly licensed code, music, photos that you can use. Now, remember, just because it's an open license doesn't mean it's in the public domain, but you are free to use it and build on it. However, because it's openly licensed content, you can't claim ownership of that underlying content. So if you're using someone else's openly licensed code, and you build on it, that underlying code is not yours. What you build on top of it, you have, but using openly licensed content can be a challenge when you're trying to claim ownership over what you've created with it.
Yeah, does that make sense? Like what we're getting there is like, you can't claim open source code as being proprietary. I've heard that a couple of times, and we just want to make sure that everybody understands that, because that can really get you into a pickle if you're operating under that assumption. So, but as Emily was saying, the original content that the original code that you're building on top of that, sure, yes, there's some potential for ownership there, but it's just worth keeping in mind if you're at all exploring open source code or open source anything.
It's really important what you were talking to the images. You know, the code is kind of etheric, but when you look at a site and it says, oh, you can use our image for free. Well, you can, but read the fine print, because you may be limited to what you can use it for. And if you start selling a product with that on it, you may be in trouble.
Yeah, always important to read the fine print on those.
So this is
Free.
yeah, because we got all these
Yeah.
websites that say, yeah, this picture's free and all that. You gotta be really careful.
Yes, exactly. That's good words of wisdom there.
So other ways you can reuse content without a license. Unfortunately, we don't have a ton of time to go into these.
Yeah.
Fair use, I just want to say it's never guaranteed. So it is a bit of a risky move. And then we did talk about public domain. That's free to use, but you just want to make sure that it's in the public domain.
Yeah, and we won't get into fair use, but if you have questions about fair use, we have a bunch of resources on our website about that, and you can always write into us as well. But it is a very specific 4-factor test that has to happen. Okay, I want to talk a little bit about contracts for like a couple of minutes, and then I'll open it up to some more questions. Contracts describe a legally enforceable relationship between two people, two entities, a person and an entity, right? And there are like a couple of things that aren't necessarily immediately apparent to people who haven't necessarily seen the life cycle of a lot of contracts. And that is that, you know, first, just because you have a contract doesn't mean that people are actually going to do what's written in the contract, right? And number two, even if there isn't a contract, that doesn't necessarily mean that things are going to go wrong, right? People could just do what they say they're going to do without issue. So in other words, things can go really well without a contract, and they can go really poorly even if you have a contract, right? And it just goes to the point that, you know, contracts aren't necessarily like magical, right? They describe this relationship between two people or entities, right? But of course they are legally enforceable. And so it's important to get everything in writing in a contract. Don't just rely on verbal conversations or just email. Email communications are great for record keeping of a lot of your communications, but emails are not contracts. In some very specific instances, an email might be considered a contract. There is some case law about that, but it's very difficult to argue. Why is that? Well, a contract has 3 basic elements, right? There's an offer, there's an acceptance of that offer, and then there's what's called consideration, which is a fancy legal term for just an exchange, like a bargain for exchange that you've made. And so with email, it causes questions about whether or not the parties truly accepted the offer or the terms of their arrangement in the email, because acceptance is normally shown by physically signing the document, right? So there's just a lot of questions surrounding acceptance if you're doing things in just email. So the best thing to do is to get it in writing. Don't start working, or don't let anyone else start working until you have something in writing. But avoid those Frankenstein agreements. And this is getting to kind of the point you were raising earlier, which is, you know, that. So first of all, like what I mean by a Frankenstein contract, it's just a contract that you've like pieced together from these like dead limbs, right? You've gone to this website and pulled this paragraph because it sounds really good. You've gone over here and pulled this paragraph, and then you have this other template that a friend of yours gave you and said, this one works really well. And you kind of mashed them all up together to bring it to life, right? You brought it back from the dead, but having like a random contract or something that's pieced together can sometimes be worse than just having no contract at all. Because again, it's really important for contracts to be specifically tailored to the particular circumstances and facts of the situation. So, and similarly, a lot of contracts are presented as take it or leave it. And if that's the case, you should at the very least understand what you are signing, and how it affects the work that you're currently doing and work that you might want to do in the future, right? You don't want to accidentally give away something that you didn't want to give away rights to. And usually you can negotiate some provisions, even in like the take it or leave it situation. And then I'll also note too, like, it's really worth discussing your contract with a lawyer, because they can spot the red flags that you might not even be thinking about, right? So again, like the Chat GPT is probably a good starting point, but the algorithm, the AI hasn't gone to law school for 3 years and practiced for X amount of years. And so they don't necessarily see or are able to do that, provide that additional context. So I think also one of the biggest problems that we see is people kind of rushing into like putting these things together really quickly because they need to rush into this deal. And then it eventually comes back to bite them because they didn't kind of slow down and take a moment to consider what are all the risks here and potential avenues of liability, and how do we build in protections against those areas of liability. And so this, I know this can be so difficult, right? Because we're moving and shaking, we're trying to go really fast, but it can be worth, and you should be prepared to be slowed down by an attorney when you talk to an attorney about a contract or a relationship that you're trying to establish. Okay. A couple of notes on contracts and copyright and how they intersect. Contracts, the short of it is that contracts can change copyright and trademark ownership rules. So the basic ownership rule when it comes to like copyright, for example, is that whoever creates the work owns the rights to the work. That is the basic rule. Now, a contract can change that because it can transfer rights away. It can also preliminarily just designate who's going to own the content. And this is, you might have heard this being referred to as work made for hire, right? So before anything is ever even created, you're entering into an agreement or a relationship whereby the creator is not going to end up owning that content. There's some specific rules around that. We don't really have time to get into it. And there's also things like joint ownership, where like two people can come together and create something. And they each own, if there's no agreement in place that says otherwise, they each own 100% of the rights. It seems really counterintuitive. How can two people, how can Emily and I both each own 100%? That's 200%. That doesn't make sense. Well, it means that, I can do whatever I want with the creative work that we've worked together on and exploit it and sell it and license it and make all this money off of it. But I have an obligation to my joint owner to pay them their equal share of the revenue that I make, not revenue, not profit, right? So joint ownership can present some issues if you don't want to do that, right? There are drawbacks and benefits to joint ownership. Maybe you don't care so much, but most people, it could kind of hang up plans that they have for exploiting that content in the way that they want to, or in the way that they want their business entity to. So keep in mind that contracts can change general ownership rules. There are a number of different ways that ownership can be affected depending on the circumstance of the work's creation. If you ever have questions or you're concerned in some way about the ownership of content that you're creating, that's a great time to reach out to a lawyer who has familiarity and experience in intellectual property law. Also, just licenses are contracts too, kind of like privacy policies in terms of use are contracts. Licenses are a different type of contract. And so again, you want to know who this other party is. Like the other party might have different interests that can affect the negotiations and what the actual end deal is. And it's important to understand what it is you're actually giving away or doing under the contract. Yeah.
If there's work that has already been produced and the creator the ownership to it, is there a way to establish a contract retroactively for that work?
So the answer there is no, but it doesn't have to be retroactive. It can be current. So a contract could like currently transfer, like if I created something and Emily wants to now own it, she can give me an assignment agreement that says, I, Erica, am permanently giving up my rights to Emily. So that is an option. That is a kind of one of the fixes to that.
Don't post it.
Yeah, don't post it. That's not a good idea. So other ways, very briefly, to limit legal exposure, exposure to liability, forming a business entity. That's not something that we do. But again, if that's something you're interested in, we do have a number of different resources in the community that we could refer you to. There's a number of reasons for wanting to form a business entity. And sometimes you got to weigh your options, which entity is appropriate. What are you most looking to protect, right? Insurance as well. There's many different types of insurance policies, but if you know you're going to be working with heavy equipment, something that's potentially dangerous, that's probably a good time to get some personal injury insurance. Errors and omissions policies can become important if you're doing anything with media, because they typically cover like infringement claims and defamation and libel, slander, those types of things. And then, okay, to kind of wrap it up, so what? Like, we just spent an hour talking about a bunch of different things that are right and wrong under the law, right? So what happens if I break copyright law? Like, why does it matter? What happens if I don't have a contract or I just decide not to follow my contract? Well, it could result in cease and desist letters, demand letters, which cost money and emotional tax to handle. Could result in a DMCA takedown, right? Copyright your work coming down from the internet. It could result in the termination of social media accounts, like your YouTube account. So if you are an influencer or you're doing anything on YouTube where you're getting ad revenue, and they have a 3-strike policy. So if you infringe 3 times, they will deactivate your account. So you lose all of your subscribers, all of your view counts, all of your ad revenue, which can be a huge deal for folks. And then finally, lawsuits, which can be taxing both emotionally and on your resources, and they're very expensive, and they can go on for many, many years too. And all of this is not necessarily meant to like scare you. It's just meant to encourage you to proceed with caution. And if you ever have questions or doubts or concerns, contact New Media Rights or another attorney. So thank you guys. I know we went a little long.
I just wanted to let everybody know at home too. I shared the link to New Media Rights. They can contact you
Awesome.
through that. And then also we'll stick around a little bit here for everybody if you have any questions. Thank you all for coming. I'm going to go ahead and stop the recording, and the recording will be available probably by tomorrow. So
Awesome.
thank you all for coming.
Thank you guys.
And
So the
extra
most
slide.
effective
Thank you.
way to waste the lawyer's time is bringing the document for somebody else. Because they're gonna charge you for reading it. Now, what it is, where it's theirs, they know exactly what's in it.
And if anybody from home has any questions, just let us
Hey,
know.
you said it. I didn't say it.
Used to be lawyers, so.
Oh, okay.